Hey everyone, Wayne Fox. Can you believe it? A couple weeks ago, the House of Representatives actually passed the CASE Act. Now, the CASE Act stands for Copyright Alternative to Small Claims Enforcement. It's a law that will set up a three-person panel or board to review small claims cases and copyright infringement. It's kind of a big deal. Right now, the only choice you've got is to go to federal court. And that means if somebody steals your picture, you got to sue them. And got to hire a lawyer, and obviously most infringements are pretty small. And not only did the House pass it, they passed it 410-6. Now we've got maybe the most partisan Congress that I've seen. I've been around a long time, and there's been a lot of bad ones, but boy, it seems like now it's one party versus the other and everything, and they never agree on anything. And yet 410, there are only 6 that didn't vote for it. I'm not sure what they were thinking, but I can't imagine the Senate would view it much differently, so that probably means that it's going to pass the Senate when it comes to a vote there sometime in the near future, and I don't imagine why the president would veto it. So, geez, it might actually make it. Now, they've tried to do this several times, and it's never even made it to a vote before. It's never even gotten enough votes to get out of committee. So it's kind of a big deal, and the question is it a big deal to you? Why am I yammering on about it, and this is my second or third video? Well, I think it is sort of a big deal. Right now, copyright infringement is pretty rampant. I was teaching a class the other day about 75 photographers in a printing workshop that I do, and I asked them how many had heard of the CASE Act, and only like 3 raised their hands. And then I asked how many had found their photograph on somebody else's website that had been stolen without their permission, and about 50% raised their hands. Now, I personally have had it happen to me. I found somebody using a photograph. I licensed the photograph to be used to a company that did a blog, and they put it on the internet, and somebody stole it from them and put it on as their banner picture in their retail space or page to try to sell the product that was involved. Now, I didn't have a lot of choice, and to be honest, most of those are pretty small, and pursuing them in federal court, the expense of doing it is just not really worth it. This is a new alternative to that, which is actually much more useful. This board works within the Copyright Office. This is their specialty. This is what they do. It sounds like it's at least a step in the right direction. If somebody steals your picture, you can file a claim, and as long as you have the right to statutory benefits, which means you registered the photograph before it was used or stolen, or you did it within 90 days of first publishing it, then you got a pretty good case, and most of the cases are actually pretty clear cut. It seems like it's a good step in the right direction. Now, there's a lot of FUD going around about how it's bad, and I thought I'd cover those things real quickly. One thing I saw several websites that says, well, this is really bad because that means the government can fine you $30,000, and it's just a way for the government to get money. And no, the government isn't fining anybody. The government doesn't get any money, other than there might be some costs involved that you have to pay the board once you win a case. But the bottom line is, this is not a fine. This is a lawsuit. And if you lose the lawsuit, that means it was determined that you stole and used the photograph or other content that creators make without permission. And the bottom line is, it doesn't matter if you made any money doing that or not, you stole it. Now, and the other issue is it's not even $30,000. Yeah, that's the maximum that is allowed in a case where you go to federal court and you sue for statutory damages, and the law allows up to $30,000 unless it's willful infringement, and then it allows up to $150,000. And I'm not sure that the board will be able to even handle willful infringement. I think if you're going to go for that big of an amount, you're probably going to have to go to federal court. But their limit is $15,000. They can't even award the full $30,000. So there's 2 FUD points. Another FUD point that they talk about is it's not being heard by judges. Well, let me ask you a question. How many judges really hear and understand copyright cases very well? There are quite a few of them, but they're not that commonplace. And to be honest, I've seen a lot of judgments made by judges that when you get right down to it, or by courts, that just don't make any sense. I think this panel will be experts in this and will be much better qualified than judges. Final point of these FUD is that it's going to create a real copyright troll problem in the country. And they compare it to patent trolling. Well, let's understand what patent trolling is. Patent trolling is companies that go buy millions of obscure patents, and Did they look around and try to find anything in those patents that's vaguely similar to some small piece of technology that somebody's using like Google or Apple? And we're talking a really minute piece here. It's like, oh, this one little thing that you do here. And then they sue for, tens of millions or hundreds of millions of dollars. It's a real problem. Well, okay, so if you want to be a copyright troll, what you've got to do is go out and buy millions of photographs, millions of them, and then try to find people that have, used them. And then you've got to take them to small claims court where you might win $15,000 even if you own the copyright. Well, that isn't going to happen. That's just not what trolling is about. They give one example of an attorney in New York named Leibowitz. They say, well, this guy's a copyright troll because he's done hundreds of copyright cases. That's all he does. Well, yeah, that's all he does, right? He specializes in copyright law. And he has done hundreds of cases. Each of those is an individual client that sought him out because of his expertise. And he does go around teaching copyright law to photographic workshops. But the bottom line is he's really good at his job and he's not trolling. He just says, hey, I'm a copyright guy. I know about it. Hire me. And so when people hire him, they hire him. Now, the bottom line is if I had a copyright case I needed to litigate, he would be the guy I'd call because he is really good at it. I've met the guy. He's sharp and he really understands what he's doing. So that's not trolling. So this FUD that's being spread around, it doesn't sound like it's caught much traction because they were really trying to slow this thing down like they have in the past. Well, so does it mean anything to you? Well, I hope so. But I guess the thought is it going to really help? Well, let's be honest. At this point, anything will help because it's a really, really bad problem. And somehow we need to get the public to be aware that they don't have the right to just go on the internet and use any photograph they want and do something with it, especially if they're going to make money. Even if they're not going to make money, they should at least ask permission. Good case, I've seen a YouTube's videos where a guy goes and takes a whole bunch of photographs from websites. He puts them together to this nice music. Then he puts out this inspirational video. Some of them are getting millions of views, which translate to thousands or tens of thousands of dollars. And yet they didn't do anything except assemble it. And they just stole all the photographs and probably stole the music. Although YouTube's pretty good about catching the music, but they don't have a good way to catch the photographs. So I think the publicity of these cases, if this actually comes to fruition, there will be probably thousands of cases because anybody can file the case. All you got to do is say, here's my picture. This is when I took it. This is when I registered it. You won't even need a guy like Leibowitz on this because you probably can do it yourself or some law student because your side of it's pretty clear. So I think the publicity will do a lot of good. Now, there's one caveat which might kind of backfire and weaken the whole thing. A lot of the FUD is that the defendant doesn't have a right to appeal. Well, sort of that's true, but the bottom line is the defendant has the right to opt out. So if you sue them and they say, you know what, I don't want to do it this way, go ahead and take me to court. That's your only choice. You got to take them to court. Now, if they agree to it, it's like arbitration. And basically, that's what this is. It's arbitration. And if you agree to arbitration, it's legally binding and you don't have an appeal. This is how it works. So if you don't think you can win, obviously your best thing to do is going to be to opt out, or unless you think you might lose a lot more in federal court. Now that's where I think the problem will be, is eventually it'll get around that most small claims, like the ones we're talking about, like you and me would file, that might be for, hopefully get $1,000 or $2,000 or $5,000. Most of those claims, we're not willing to go to federal court. And so most people are just going to opt out and try to force the hand. So I think eventually over time, the law will get pretty weak because of the opt-out clause, and it might actually wash out and be pretty much worthless. So anyway, I'm going to follow it. As soon as the Senate does their vote, I'll do a quick update video. And if it goes to law, we'll kind of see when it comes to place and we'll kind of see what happens. Hopefully photographers and other content creators that spend a lot of energy trying to create work have a new way to protect their copyrights. Well, thanks for watching the video. Don't forget to subscribe to the channel. Hit that button down there. I've got a couple new ones on Lightroom coming out pretty soon. So anyway, until next time, see ya.